here, things only get better with time. It's why we've perfected the art of the scenic route, and why we also love a game that takes all day to play. It's why we know that when we welcome old friends again, everything that's great here will be even better. 'Cause whether it's a long walk, a long lunch, or a long-awaited hello, there's nothing like Australia.
We are delighted to welcome you to the 14th Jaipur Literature Festival protected by Dettol. Today's session is produced in partnership with the Australian High Commission. It's a pleasure to present today Constitutions and the Foundation of Democracy. Albie Sachs, Akhil Reed Amar, Madan B, Lokur and Meghnad Desai in conversation with Pragya Tiwari. As fault lines within democracies continue to disrupt and widen across the world, we examine the crisis at its root through the prism of constitutions that have set up the framework of these social institutions. With an emphasis on the foundational ideals and grounding philosophies guiding the making of this pivotal document, an eminent panel of legal representatives discuss its unique trajectory and continued relevance across the world in terms of both interpretation and implementation within the context of our present times. Albie Sachs is an activist and a former judge on the Constitutional Court of South Africa. American legal scholar Akhil Reed holds the position of Sterling Professor of Law and Political Science at Yale University. Justice Madan B. Lokur is an Indian jurist. He is a judge of the Supreme Court of Fiji and is a former judge of the Supreme Court of India. Meghnad Desai is Emeritus Professor of Economics at the London School of Economics and a member of the British House of Lords. In conversation with writer and columnist Pragya Tiwari. Albie Sachs began practicing as an advocate at the Cape Bar at the age of 21, defending people charged under the racial statutes and security laws of apartheid. After being arrested and placed in solitary confinement for over 5 months, Sachs went into exile in England where he completed a PhD from Sussex University. In 1988, he lost his right arm and his sight in one eye when a bomb was placed in his car in Maputo, Mozambique. After the bombing, he devoted himself to the preparations for a new democratic constitution for South Africa. When he returned home from exile, he served as a member of the Constitutional Committee and the National Executive of the African National Congress. He is the author of several books, including The Jail Diary of Albie Sachs, Soft Vengeance of a Freedom Fighter, The Strange Alchemy of Life and Law, and We the People, Insights of an Activist Judge. His latest book is Oliver Tambo's Dream. Akhil Reed Amar is a Sterling Professor of Law and Political Science at Yale University. He has been cited by the US Supreme Court in over 40 cases, tops in his generation, and has regularly testified before the US Congress. Madan B. Lokur served as a judge at the Supreme Court of India from 4th June 2012 to 31st December 2018. Justice Lokur is presently a judge in the Supreme Court of Fiji, the only Indian to be appointed a judge of the Supreme Court of another country. Meghnad Desai is Emeritus Professor of Economics at the London School of Economics and a member of the British House of Lords. He received the Pravasi Bharatiya Puraskar in 2004 and the Padma Bhushan in 2008. His recent publication, besides Rebellious Lord, is Anamika, A Tale of Desire, set in times of war. In conversation with Pragya Tiwari. Pragya Tiwari is a journalist who has written extensively on politics, identity, policy and culture. She is the co-founder and editor of the Indian History Collective. Ladies and gentlemen, now presenting Constitutions and the Foundation of Democracy. Albie Sachs, Akhil Reed Amar, Madan B. Lokur and Meghnad Desai in conversation with Pragya Tiwari. Enjoy the conversation.
Thank you very much, Jaipur Literature Festival, all of you guys, for giving me this opportunity, this huge honor and privilege to be speaking with such an illustrious panel. But as much of an honor as it is, it's also hugely challenging because we have all of 40 minutes between 4 speakers who have so much of value to say on the subject at hand. So I'm going to try and keep the focus narrow. Over the last couple of years, there's been a lot of conversation around the world about democracies being in crisis. What we're going to try and do today in the time that we have is examine the health of democracies through the prism of constitutions that create the framework for their existence, and the role of these constitutions in both creating, shaping, as well as safeguarding democracy. And to that end, perhaps it's best to start at the beginning with the process of writing constitutions. Now, there are at least some countries where a case can be made that the form of democracy that has been sort of adopted and the circumstances in which the constitution that creates the framework for the democracy have, are sort of rife with questions about whether or not the ideals that and the principles on which these democracies and constitutions stand are not imported from the West, and whether they sort of align with the lived reality of these countries and societies. For example, one could talk about the sort of right to property, or the tussle between individual rights and community rights, which are traditionally thought to be so central to constitutions, but the way in which they pan out in certain societies, particularly via the form of democracy, may not always be ideal for them. Even countries such as India and South Africa, where one might argue that the constitutions are really sort of homegrown, there's been a long process of debate and discussion before the constitutions were adopted. That's, the challenges have been sort of enormous. I mean, our first Prime Minister, Jawaharlal Nehru, is believed to have said that his biggest challenge is to create a secular republic in a deeply religious society. And even in South Africa, where again it's arguably a very homegrown constitution, there have been critics who have blamed the constitution for many problems that the country has faced. So to that end, I would like to start with Justice Sachs and get your views on the having in retrospect been a part of history making in terms of adopting the constitution. What are your views of the ideal process of enacting a constitution and giving of shape to democracy in a new country?
And I've got 2 minutes to say all that. But let me start and even use a few of those seconds to say why I was so thrilled to be invited to the Jaipur festival. Partly, India played a huge role in terms of our imagination of constitutionalism. And the whole idea of having a constitutional assembly, which you pioneered in India, became foundational to our constitution-making process in South Africa. We refused to sit down with the whites round the table to draft a constitution the way they wanted when they were in power. We said only a constitution drafted by a body mandated by the people of South Africa could get a constitution that would be enduring and legitimate. And we looked to India as the example of where that had happened, with huge involvement. And India played such a big role. The content of your constituent assembly, the style, the participation, it wasn't just left to lawyers to draft a constitution. And we battled over that. We ended up having a two-stage process of constitution making, where we sat around the table in South Africa to have an interim constitution, to get elections, to get the final constitution. And you'll see a huge difference between our interim constitution, when we were relatively disempowered, and the final constitution, where 400 people, half of whom had been in jail, in exile, in the resistance, a very powerful women's movement, very strong labor union representation, got a very, very progressive constitution. And even our property clause does not entrench property rights as such. It simply entrenches the right not to be arbitrarily deprived of property. We also took from India social and economic rights as fully enforceable rights in our constitution. We were a step ahead of you. And in addition, we'd had the experience of meeting judges like your former Chief Justice Bhagwati, I met Krishna Iyer. These were great judges. They set an example of what a top court could be, a court that reached out to the people, a court that somehow fulfill the promise of the Constitution that the executive and parliament were failing to fulfill. That's anticipating a little bit one of your later questions. So this is to say thank you to India. Maybe in some respects, our court now is playing a more vigorous, more vibrant role than your court played in those days. But you gave us the energy, you gave us the spirit, you gave us the idea of a court with a very broad mandate. And I'll just end with this. One of my colleagues, Sandeep Noble, who went on to become Chief Justice, said, in a constitutional democracy, the hands of justice are never tied. You can't say, I'm sorry, the law says it's unjust, it's unfair, but we leave it to Parliament or somebody else. We as judges can do nothing. In a constitutional democracy, judges cannot say, I see injustice in front of me, but it's not my responsibility. Because the very nature of a constitution with fundamental rights doesn't allow for vacuums where people's rights can be undermined by the law, or through negligent application of the law.
Thank you for that, Justice Sachs. And again, apologies for really making you answer this question in a minute. But moving on to you, Professor Amar, you've written wonderfully, and for all those of you who are listening, just go back and read what Professor Amar, and for that matter, all our speakers have to say about the subject. But I'm curious to hear your thoughts about how, America as a democracy has fared in the context of the original Constitution and the way in which it was adopted, keeping in mind the history and the peculiar circumstances, the society and culture of the country and everything that was going on then.
Thank you very much. It's a very great honor to be with you and on such a distinguished panel. My parents were born in undivided India. They're still with us today. And unlike South Africa, that could look to an Indian democratic constitution-making experience, the Americans, of course, couldn't do that because the Indian constitution had yet to be born. But they did look to their own, they did look to experience, and the US Constitution looked in particular to the lived experiences and the democratic experiences of the 13 mainland colonies turned states, the entities that declared their independence from Great Britain in July 1776, and 11 of those 13 actually inaugurated their own constitutions, beginning in 1776. And the US constitutional experience tried to learn from the state constitutional experience. And in most respects, it tried to adopt best state practices, both in the process of making the Constitution and in its substance. So here are the best state practices. One, how do you adopt a constitution? Massachusetts did it the best way. In 1780, it was more democratic because it put its constitution to a special vote in which actually there were no property qualifications among the electorate that was asked to ratify the Constitution, and the Constitution had been proposed by a special ad hoc assembly. Those were reforms that Massachusetts introduced in 1780 that, for example, Virginia had not followed in 1776. So states began to experiment. They built on each other. Massachusetts was better in its constitution-making process, more democratic, and the US Constitution followed that. There was a special Continental Convention that met. It proposed a document. It was specially ratified, and in that ratification process, we, the people of the United States, do ordain and establish the Constitution. In 8 of the 13 states, the ordinary property qualifications that applied to ordinary elections were lowered or eliminated. In 2 of the other states, there really weren't property qualifications, and in no place was property qualifications raised. So both in substance and in a process, the US Constitution follows state constitutions, and it was a largely, it was a mixed success because it also protected slavery in very emphatic ways, and that was going to lead ultimately to a civil war with important amendments, and women weren't enfranchised at the beginning, and so there would be amendments after that in the 20th century. So it has been an ongoing process.
Thank you for that, Professor Amar. Justice Lokur, very quickly, your thoughts on, there's this sort of, on the one hand, we can argue that we truly have a homegrown constitution. Baba Saheb Ambedkar, Dr. Ambedkar definitely argued that we do, but at the same time, both he and both Prime Minister Nehru seem to be sort of wary in terms of how it'll play out. The constitutional value, the preservation of constitutional values will play out vis-a-vis the political culture that was to come. Your thoughts on that?
Yeah, well, thank you, Pragya, and thanks to the JLF for giving me this opportunity to share my views. You know, our constitutional culture, actually, if I may say so, the 1935 Government of India Act, was in a sense like a pilot project, right? Of course, that was given to us by the British government at that point of time. But the 1935 Act laid the basis or the foundation for the Constitution of India that came eventually. There were a couple of drafts of the Constitution of India, one by Sir Benikal Rao, by the Constitution Committee and so on. The debates went on for more than a year in the Constituent Assembly. And that's when the document came out. Of course, there were differences, amongst members on how to proceed further. But I think by and large, there was a consensus that the constitution that we are adopting is the one that is best suited for India. Now, it has worked very well, although right in the beginning, the first amendment actually came within a year of the introduction of the constitution. So it has worked well, but there have been a lot of amendments, and like Akhil said, it's a process of evolution. It moves, and so we are still learning. In spite of the fact that some of the brightest and the best in the country drafted the constitution, we are still learning, and changes are being made. Although I would say that maybe in the last 10 or 15 years, or maybe 20 years. The number of amendments that have been made to the Constitution are far less than what they were in the initial stages. So yeah, it's an interesting development.
Thank you, Justice Lokur. Coming to you, Lord Desai. What Justice Lokur has just raised is sort of points us to a more fundamental question, which is, what do we speak of when we speak of a constitution? And that obviously takes us to that little bit of friction between the written constitution and the unwritten constitution. And the age-old sort of debate about the freedom that judges and courts should have in terms of being able to read between lines and interpret the constitution in the context of original ideas, first principles, etc., keeping in keeping with the times and the demands of a democracy, versus restraining judicial activism and changing constitutions through amendments. As of course, Justice Lokur rightly pointed out, we've been doing in India time and time again, and the implications that that has for democracy. You've written, you've in an interview, you've spoken about it, and you've had some fascinating views. So I'd love to hear your thoughts on that, Lord Desai.
Thank you very much. I'm the only person who's not a lawyer. And I must also say that I'm immensely humbled to be in presence of such legal scholars and judges. I'm not often humbled, so I can tell you that's a rare event. I can take three constitutions in which I have, as it were, passed in between: the British, the American, and the Indian. And the British Constitution, they say, is unwritten, but it's not unwritten. There are piles of stuff written, but written not at one point of time, but written over the number of years. After all, we had a judiciary which was not actually independent. It was part of the legislature. It was a committee of the House of Lords until about 13 years ago. Then, of course, the 1688 Constitution, which the Americans took, and then added separation of powers, that they took ages, as Professor Amar said, that took ages to have universal adult franchise. America still doesn't have universal adult franchise because franchise is limited by which state you're in, whether you got a Republican government or a Democratic government, if you're black. Now, India is very unique in being the only constitution which started with universal adult franchise. It's an extremely rare thing that at the beginning, the founding fathers and mothers took the decision. And that comes from the independence movement. That came from the fact that the Congress was built on mass membership, and the Mahatma, good barrister, saw to it that women and men were equally part of the movement. And the Constituent Assembly itself was elected on a very limited franchise. The franchise was on property, but still the experience of independence movement, very much like what Judge Albie Sachs said, because the people had been in jail and had been out there, they built a constitution which was very, very different. But when they became rulers, they suddenly realized this is a constitution of the mob. We've got to get under control. So Amendment 1, I'm sorry to say, restored the pre-independence set of limitations on the fundamental rights. And I think there has always been this kind of struggle in Indian democracy between the right of the center to rule, and rule with an iron hand, like the colonials used to rule, and the habits that the Mahatma gave to the people, saying, if you don't like it, sit down in the street and defy. And that balance has been the very interesting thing in India, just in the last 3 months. The way the farmers have sat down in the road and said, we don't care. You pass this law, but we don't want the law to be passed. Withdraw it. Now, that kind of attitude tells me that constitutions matter not so much as what the people do to the constitution. What people, my political career, such as it has been defiance of whatever the government does. I'm been in an opposition party for a long time. So my perspective is, whatever the Constitution says, you bloody well defy it and ask them to change it by breaking it or violating it in some way. And so I think one must never lose the faith that whatever the Constitution may say, the people have the reserved rights, basically by placing their body in front of the police to say, change this. And in a sense, one more thing to add, which was said, behind the Constitution, especially of this tradition, the British tradition, there is not only the Supreme Court judgments of one country, but every other country which has the English rule of law. So a judge can cite, I'm sure, judgments from South African court or British court or American court. And so the corpus of law is very large and can come to our help as citizens. And I respect the law and the lawyers because they are my last recourse against the government. The governments I don't trust. I don't trust governments. I trust the law and I trust democracy. Sometimes governments are good. Most of the time you have to fight them.
Thank you for that, Lord Desai. Professor Amar, I feel terribly embarrassed asking you. You brought so much nuance to this debate between written and unwritten constitution, and I feel terribly embarrassed to ask you to sum it up or say a couple of lines about it, but here I am anyway, asking you to do that. So please, the mic is yours.
Thank you. So ours is a written constitution system in the United States, but yes, we also have an unwritten constitution. And I think you stated it very well when you used the metaphor of reading between the lines. And that's not making things up, but it is interpolating. And so the challenge is to have an unwritten constitution that doesn't unravel the written constitution. I'll give you just 2 examples. One, before our First Amendment in the United States proclaimed that there was a freedom of speech, that was already between the lines of the written Constitution because it created a democratic system, and you can't have a democratic system with free and fair elections unless there's very broad political speech, or right of political speech. And indeed, our friends in Australia, who do not have an express provision affirming freedom of speech, have interpreted as implicit between the lines of a written constitution that's about a democracy with free and fair elections and multiple political parties that are allowed to vie for power. That's one example of reading between the lines. Even before US First Amendment, there was freedom of speech in America. It was actually part of the very process by which the Constitution was adopted, with robust, uninhibited, wide open debate about whether to vote yes or no on the document. Second example, the United States Constitution has a written Bill of Rights. And if it's written, I say it bloody well needs to be enforced. People died for that and risked their lives for that, like Albie Sachs and many others. So if it's there, we enforce it. But in the US Constitution, there's a provision that says there are more rights. There are unenumerated rights, not fewer than are textually specified, than are written, but more. It's our 9th Amendment, and then there's actually a provision of the 14th Amendment. Where do we find those additional rights, which are to some extent unwritten in that they're not in the US Constitution? Well, we look to state constitutions, we look to lived experiences, we look to how constitutions have actually, the very process by which they've been adopted and amended, involving, for example, free speech. So there is a disciplined process by which the written constitution can go beyond, beneath, behind, the unwritten constitution can go beyond, beneath, behind the written without unraveling the written. It's a beautiful dialectic.
Thank you for that, Professor Amar. Moving on to the two justices that we have with us. Justice Sachs, I'll start with you. There is, when we talk about judicial interpretation, when we talk about reading between the lines, the sort of misgiving that one could always have is the extent to which ideology might play a part in interpretation, and how that might pan out in terms of a democracy, given that obviously judges are not directly elected in most countries by people. I want to get your sense, before I move on to Justice Lokur, of the role of courts and judges in not only interpreting constitutions, but sort of keeping them alive in order to keep pace with all the various factors that impact the health of a democracy. And of course, those factors have changed over time. We live in times where there's sort of, globalization, there's sort of digital threats to democracies, et cetera, et cetera. So again, a vast question and a couple of minutes, and the floor is yours.
No, it's okay. I love your emphasis on keeping the Constitution alive. It's not an old parchment, historic document. We've got to go back to what were they debating and thinking at the time. To me, that's ludicrous. Constitution lives in the minds of the people, clamoring for their rights, feeling they're citizens, belonging to the world, feeling I matter, everybody counts. My mind is going back a little bit. The first time I met Chief Justice Bhagwati, I felt awkward. I just sensed he'd been to jail. I don't know how we ex-cons smell out each other, but you don't ask a former Chief Justice, excuse me, sir, did you go to jail? So I asked him about his career, and he told me that he actually started 2 years later than his colleagues at university, because the British locked him up for 2 years. Now, sometimes I think every judge should be locked up, maybe not for 2 years, but for a certain measure of time, to feel the impact of the law, what it means, what sovereignty, power means, to experience it, even if they know they're going to come out easily afterwards. But it explained so much to me, that golden phase, if you like, in the judiciary in India, where it became a beacon to the world and inspired judges to look at constitutions not just as verbal texts, to pick up the Oxford English Dictionary and then find something in the Chambers American Dictionary and play around with definitions. The definitions of life, of experience. This is what we really wanted. And we found it in his generation. And to me, it wasn't just doctrine evolving to demand a change. The doctrine adapted. It was living, because he felt ashamed as a judge to be applying a constitution that left prisoners without rights, that left poor people without rights, that allowed people in factories to inhale fumes and get no remedies. Where's the justice? There's something wrong in the justice. So to be more democratic, to fulfill the vision, not to impose our vision, the vision of the people who drafted the Constitution, who fought for the Constitution, who kept it alive during this times of emergency afterwards. That's what we have to do. So we have the living tree doctrine of the Constitution. I happen to be one of the persons who wrote the South African Constitution. I'm one of the original intenders, if you applied that archaic American doctrine. And I was actually asked by, at a lunch one day in the Supreme Court of the United States, Justice Alito said, "Excuse me, Justice Sachs, but would you say the Constitutional Court of South Africa is an activist court?" And I said, "Yes, Justice, but we have an activist constitution. We have a very powerful preamble that speaks about the injustice of the past. We look at the Constitution not as clauses in an insurance policy or statements in a will, a Constitution produced by struggle to look after the basic rights of people who are clamoring, the marginalized, the poor." And what I wanted to tell him was the most activist court I know in the world today is your court, Justice Alito, and you are one of the most activist judges yourself. You strike down campaign finance that's been passed by Congress. You strike down voting rights laws. You strike down a whole series of laws that were there to empower the people. Gun control laws, you strike them down, even although these were laws passed by the local assemblies. So you are very activist. But when you're activist in favor of property, in favor of power, in favor of the entrenched elite, then you say we are neutral. Whereas when you're activist in favor of the disabled, the marginalized, the disregarded, then you're said to be activist. We are all activists. Let us declare whether we are activists in favor of the inherent core principles of justice, freedom, human dignity in the Constitution, or are we activists in favor of preserving a status quo that is unequal?
Here. And it's funny that what you mentioned about what you said about judges being in prison and how maybe perhaps they should go to prison reminds me of this essay. I don't know if you've read it, that Pandit Jawaharlal Nehru wrote, called The Mind of a Judge. And he wrote it, of course, when he was, I think, in prison. He wrote it for the Modern Review, which sort of suggests the same thing. Of course, he was talking about the British colonialists at that time. But Justice Lokur, the sort of tussle between the temptation to capture state power, when parties are, in the position to do so, and what constitutional courts can do to safeguard constitutions and institutions and democracies. I would like to get your thoughts on the areas of improvement when it comes to appointment of judges and ensuring the independence of the judiciary. Of course, this also comes, for those of you who may not be aware, Justice Lokur has not just written prolifically about this, but he was also part of a slightly unusual press conference that drew attention to sort of a kind of rot that needs to be stemmed when it comes to these issues with regard to the Indian Supreme Court, the Constitutional Court in India. Over to you, Justice Lokur.
Yes, the issue about appointment of judges is something which is very vexed so far as India is concerned. Right? We've tried out, power being entirely with the executive initially, then transferred to a collegium of senior judges of the Supreme Court, But I believe that there is no perfect way of appointing judges, right? They have a different system in the United States. They have a different system in Europe, and we are still searching for the right way, or the more appropriate way, if not the most appropriate way of appointing judges in India. So we are going through this catharsis, so to speak. But yes, ultimately, I think something will come out of it, because we need to tweak the existing systems. Now, the problem really is that, which was articulated by Dr. Rajendra Prasad, the first president, and he was also the chair of the Constituent Assembly. He said that, you may have an excellent constitution, but if the people who are going to man the institutions under the constitution do not have, the right spirit, then however good the constitution may be, it's not going to work. And you may have a terrible constitution or a terribly written constitution, but as long as the persons in charge of institutions have their heart in the right place, well, it doesn't matter what the constitution says. We are having this problem. We've had this problem in the past. We had this emergency, for example, in India. Today, I'm a little sorry to say that, but we are also facing this kind of a problem where we have an overpowering political executive, which is dominating, in a sense, the judiciary in India. So let's see how this pans out. It's bound to have an impact on the appointment of judges. We've already had very recently, some recommendations made by the Supreme Court being turned down by the political executive. So let's see how it plays out. It's maybe, we are still in that process. But I would also like to just say a word about, what you said about reading between the lines and judicial activism, which Justice Albie Sachs had mentioned, and also Akhil. We are looking, our judiciary is looking at what you might call the, reading between the lines, or the gaps in the constitutions, or the what the Americans say are the silences in the Constitution. We are looking at those to have an impact on society, to improve society. That's where Justice Bhagwati, Justice Krishna Iyer, and many others that followed, played an activist role. But today, that kind of activism is being denigrated. It's judicial activism today is being looked at as a sort of a pejorative term. That's unfortunate, So there are a lot of changes that are going on right now, as we speak, and over the last maybe 6 months or so. But yeah, it's going to be interesting times ahead, and let's see how it pans out.
I've been told I have 10 or 12 more minutes, and I still have 2 questions. So I'm just going to go right to it. First, a sort of shorter question. Justice Lokur, you talked about it. All of you have sort of talked about, Lord Desai, you've spoken about the minds of the people, Constitution living in the minds of the people. My question is, are substantive rights and empowered, independent, ideal courts even enough? What is the role that checks and balances of institutions and executive, as well as the will of the electorate, how much role do they have to play in terms of keeping constitutions alive? And I'll start with you, Lord Desai, and perhaps go with you.
Yeah, let me just continue this thing about how judges are chosen, which is a very interesting point. You see, in a sense, again, in the 3 different countries in which I have lived, the American thing is very interesting because the Supreme Court judges are for life, but they're appointed by the president. And that is a very interesting thing. And every time there is Donald Trump was very lucky. He has 3 Supreme Court judges appointed by himself, and he's openly partisan. The process is openly partisan. There's no nonsense. There may be separation of power, but the judiciary appointments are done by the executive with the Congress in the favor. In India, it's very interesting that to begin with, it was the executive which used to appoint justices, and then it moved when a collegium came up and the Supreme Court became important. And now there is a tussle going on between the executive and the judiciary as to who appoints. In UK, of all the things, we had the judges sitting in the House of Lords, appointed by the Lord Chancellor, and the Queen or the Crown could appoint people to the peerage to be a law lord. And that was a completely corrupt system, but it was extremely independent because the basic culture, political culture of the country more or less believed that a crown should not interfere in what the judges do. And I was part of this sort of small movement which said we have to have separation of power, and we have to have judiciary out of the legislature, and we have to set up a Supreme Court. And the Supreme Court independently was set up only about sort of 15 years ago. We now have a Supreme Court. And judges can only sit in the House of Lords after retirement. And I would actually say to the Indian government, adopt our policy. Every Supreme Court Chief Justice becomes a member of the Rajya Sabha upon retirement. Because we can use that experience. But you know what really I'm trying to make, there has to be a culture in the country over and above all written stuff, which has a basic respect for the law. The law, which is more than just the Constitution. You know, law is something about fairness, about respect for history, and accommodating change. Accommodating change is the most difficult thing because, again, as an American Constitution, until that man Floyd died, the whole question of black rights was very subdued. I mean, it was there, but it's flared up in the last 2 years because people said, you know, in the 21st century, we will not tolerate the way black people are treated in America. Simple. And, you know, so people have to, you have to have this tradition of respect for law, but also activism on part of the people. People are the active element. Sorry.
Thank you, sir. I'm going to, this is my final question, and I'm going to go around the table with this one, but also please use this opportunity to share any other thoughts on any other questions that you might have. And this question is that, you know, when we, in common parlance, when we talk about safeguarding the Constitution, one can just sort of assume that we are talking about safeguarding the democracy as well. However, there can be instances when there is a sort of friction between constitutional principles and deepening of democracy. And in order to sort of illustrate this for our audiences with an example, I will go back to the First Amendment of the Indian Constitution that a couple of speakers have referred to. Now, when that amendment was coming about, it is believed that Prime Minister Nehru had said that, you know, the sort of 19th century was about ideas of fundamental rights, individual liberty, but sort of the 20th century belongs to ideas of social reform, social engineering. And he was, of course, referring to giving quotas, providing quotas for disenfranchised castes. He was talking about land reform. He was talking about nationalization of industry. And there was a sense that sort of judges using constitutional principles were blocking some of these reforms. And so his law minister, Baba Saheb Ambedkar, and the Prime Minister himself, both people who were great champions of the Constitution, ended up passing an amendment that kind of limited the fundamental rights guaranteed by it. And this can be seen as an example, and this obviously begs the question whether the means justified the end, but it also illustrates how deepening of democracy can sometimes clash with established constitutional principles. So final thoughts on this, and I will start with you, Justice Sachs, and anything else that you'd like to comment on.
Yes, first of all, I'd like to support Lord Desai. He speaks about the culture of constitutionalism. And I think, where would I rather be locked up? In Washington with a powerful constitution, or London with no written constitution? And to be honest, I'd rather be locked up in London, or in Oslo, or in Amsterdam. And after I was blown up, I worked on preparing for our new constitution in South Africa. And I thought, let me go to the social democratic countries of Northern Europe to see their constitutions. And their constitutions are nothing. They're quaint historic documents. So I developed my regicide theory of fundamental rights. When you execute the sovereign, you need a doctrine, a compact, an agreement, who exercises sovereign power. I actually mentioned this to Princess Anne one day, and she said, I'm dropping names now. Oh, I do hope we can get a Bill of Rights through drastic means in the United Kingdom. But the point is, if you have a spirit of constitutionalism, you can get more protection than from a written document. On the other hand, all over Africa, we had constitutions drafted in London, torn up very, very quickly, had nothing to do with local realities, and disrespected culture, power, and the new people who became the bosses. So a constitution without constitutionalism is worth very, very little. And what you need then is not simply the people, of course you need the people, and not simply the written text of a constitution. You need everybody in society, the journalists, the lawmakers. They're just things you do and you don't do. And they're so deeply penetrated into what's appropriate and what's inappropriate. That provides the connection between what the masses, the people, the underprivileged want, and those exercising the instruments of power, what they want. In South Africa, in fact, we had very severe problems. You were kind of politely hinting at them, of corruption, of abuse from people high up in power in South Africa, of Parliament not doing its job, of the presidency not doing its job. And it was the court. I was off the court by then. The Constitutional Court of South Africa ordered our president to pay back money overspent on his house, enforcing the law. It was dramatic for the whole country. It revitalized Parliament, and it helped to restore the dignity of the president. The current president is very, very sensitive. So the activist court, if you like, intervening to hold Parliament to account, to hold the presidency to account, enforced apartheid, it reinvigorated enforced democracy, reinvigorated the democratic system. The judges, in that sense, far from being the opponents, were the guardians. Lochner in America, the old Supreme Court, used that to strike down ordinary laws of limits of number of hours that people could work. All social legislation was struck down. But that was a debate of 100 years ago. That was when the activist judges were stopping social legislation. Today, modern judges, many of my colleagues in many parts of the world, are very progressive-minded. We come from different backgrounds. Some are religious, others not religious. Some voted this way, some that way. Some were like one side of Lord Desai, very obtuse and anti-government. Others were like the other side of Lord Desai, very respectful of government. That's what makes him such a wonderful personality, because both these trends are inside of him. We had all of them on the bench. It was very moving for me. The Constitution becomes the prison for people with different personal backgrounds, who've been in jail, not in jail, quiet, loudmouth, everybody's there. The Constitution enables us to come together, to do something for the nation, for the people, to pick up these historic things that people have fought for all over the world, whether it's in India or in America or in South Africa or in Fiji. And I used to say, workers of the world unite. Today I say, judges of the world unite.
Very good.
Brief. If we start with courts, we need to understand that, at least in the United States, presidents pick judges and the people on election day pick presidents. So we move very quickly from courts to democracy. This is why I so agree with Justice Sachs that voting rights are absolutely essential. I was so disappointed when the United States Supreme Court invalidated major portions of a Voting Rights Act that came from Congress and not the Supreme Court. I think that was the worst decision of the US Supreme Court in the last 15 years. And elections in turn require more than merely voting rights, but very robust protections of political expression, especially expression critical of the government, so that our elections are free and fair. And ultimately, that without free and fair elections, broad protections of political expression, and robust protection of voting rights, nothing works.
Thank you for that. Justice Lokur.
Yeah, thank you. You see, so far as our constitution is concerned, Indian constitution is concerned, Pandit Jawaharlal Nehru was an idealist, right? I mean, there's nothing wrong in that. But I think over the years, the aspirations of the people seem to have been forgotten. And I think Lord Desai is right in saying that, we have to get back to the people to understand how do we read the Constitution. We've had two very, important events in the last couple of months in India. Well, last year, we had this agitation about the Citizenship Amendment Act. The entire movement was led by women, right? What was in their mind, and what was in the mind of the legislature when they came out with the enactment, right? There was obviously a disconnect. Lord Desai mentioned about the farmers, on the road in India. They've been there now for, I think, about more than 75 days. Again, a disconnect between what the people thought in this scenario, a section of the people, the farmers, and what Parliament thought. So really, I think this is perhaps what Akhil is also trying to say, and Albie Sachs, Justice Albie Sachs has definitely said so, and so has Lord Desai, that it's the people who are important, and they are the ones who determine the Constitution. They are the ones who determine the judgments of the courts, and they are the ones who determine, how the law should progress. Yeah, thank you.
Thank you. I'm being told repeatedly the time is up, but it'd be criminal not to give the last word to Lord Desai. So final thoughts, Lord Desai.
I think the biggest danger is majoritarianism. Nehru presumed that he had the mandate of the people to make social change. Indira Gandhi actually said publicly that she had the mandate, and therefore anybody defying her, she could impose emergency. And emergency was constitutionally imposed. And today, the government in India also thinks it has a majority. It has had majority twice in succession. Therefore, it can do what it likes. It is at that point where democracy and the Constitution come into a conflict. And I think, again, the only final judge are the people. They will determine who is right. And they drove away Indira Gandhi. They called Indira Gandhi defeated after a while. And I think that is the only hope we have. Only hope we have in any democracy are the people.
Thank you so much. Thank you, all of you, for tolerating very patiently my vast questions that I posed to you in matters of minute. It's been a privilege to speak with all of you. Thank you, JLF, for giving me this opportunity.
Thank you very much. Great honor. Thank you.
Thank you, Albie Sachs, Akhil Reed Amar, Justice Lokur, Lord Desai, and Pragya Tiwari for this captivating and informative session. Thank you for being part of Jaipur Literature Festival 2021. It was an honor to have you all here. Thank you so much. We would also like to thank the Australian High Commission for supporting this session and our celebration partner, Diageo. Thank you all for watching and being such a great audience. Please stay logged on to continue to watch with us the series of exciting sessions featuring a stellar list of speakers that have been specially curated for you. As you're aware, the cultural sector has been critically impacted by the pandemic, and while we have braced ourselves to embrace the new normal, we have struggled to ensure that we can continue to bring you a free flow of knowledge and ideas. We'd love for you to support us at Timber Cards. Any contribution is welcome and would help spread knowledge and ideas seamlessly against all odds. You can also tweet using hashtag Jaipur Literature Festival 2021 @JaipurLitFest. The festival is protected by Dettol. Hope to see you in the next session. Thank you.
Down here, things only get better with time. It's why we've perfected the art of the scenic route, and why we also love a game that takes all day to play. It's why we know that when we welcome old friends again, everything that's great here will be even better. 'Cause whether it's a long walk, a long lunch, or a long-awaited hello, there's nothing like Australia.